The first matter before the court this morning is York 2472, High Maine versus the town of Kittery. I see counsel are here. What I'm going to ask is that you introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honors. Zach Brandwein for Appellant High Maine, LLC.
Good morning, Your Honors. Cameron Ferrante for the appellee, town of Kittery.
Thank you.
Good morning, Steve Langsdorff with the town of Kittery.
It's my understanding that Mr. Ferrante will be arguing. Is that correct? Thank you. We are being recorded both by video and orally. I believe we're also being streamed on the web. If you are ready to proceed, Mr. Brandwein, we'd be happy to hear your arguments.
Good morning, Your Honors. As you know, my name is Zach Brandwein, counsel for the Appellant High Maine, LLC. I have waived my uninterrupted time. I'm happy to take any questions that the court has.
All righty, let's start.
Justice Connors?
So, do you agree that because of the procedural posture in which this case is presented to us on a motion to dismiss, all we can rely on to determine whether you have standing or not are the allegations in the complaint?
I do, Your Honor. I think the record and the code that was included with the record is also relevant and properly before the court.
Well, all we can do in a motion to dismiss is view liberally and most favorable to you and construe generously, but we have to look only at the allegations to see if you have standing based on those allegations in the complaint.
As to the facts, Your Honor, yes.
Okay. So where in the complaint allegations does it indicate that your client is qualified and would be able to have a license?
Your Honor,
If everybody ahead of you got disqualified, where does it say you are qualified to get the license?
Your Honor, the complaint doesn't speak to High Maine's qualifications to obtain the license. What it does speak to, as you'll see in complaint paragraph 8, which is appendix page 10, is that High Maine submitted a pre-application. Included with that pre-application were a number of requirements imposed by Town Code, section 511(9)C, which included payment of a pre-application
None of
fee.
this is in the complaint. All that is in the complaint in paragraph 8 says you filed an application.
I agree, Your Honor. In appendix pages 40 and 41, those are portions of the code upon which the court can rely in this appeal. Those include the requirements that were included with the pre-application when High Maine submitted it.
But there's no factual allegation that you meet those requirements.
I don't believe that's relevant to determine standing in this appeal, Your Honor. What's relevant is High Maine submitted a pre-application.
Isn't that what would separate you, though, from other members of the public in terms of the injury?
What separates High Maine from other members of the public, Your Honor, is that it is on the wait list. It submitted a pre-application. Members of the public that did not submit a pre-application and are not on the wait list would not have standing to challenge the town's regulatory actions in the administration of the wait list.
Is being on the waiting list, is that a protected property right or personal right? All you have to do is file an application and you're on the waiting list, right?
Well, it's not just respectfully, Your Honor, it's not just an application. It includes a number of requirements. As I mentioned, the fee. It includes the requirement to submit right title and interest to the premises at which the business is to operate, and it includes a requirement that the pre-applicant demonstrate that it has submitted an application to the State Office of Cannabis Policy.
But any member of the public can go ahead and file the application with the fee and the other materials, right?
But any member of the public did not do that. And I suggest that any member of the public can't just do that. That requires an investment of time, energy, and resources, which are demonstrated by the code section that lays out those requirements. The definitive factual issue in this case that gives rise to standing is the wait list and the pre-application that pre-applicants are required to submit to be on the wait list.
So he gets standing just by filing the pre-application?
Well, this case is distinguishable from other land use cases where an applicant just fills out a one-page form, right, which is a common thing in land use matters. This is not that. Pre-applicants in this case are required to adhere to a pretty rigorous regulatory scheme imposed by the town, which includes the expenditure of time, energy, and money to put forth a pre-application and secure position on the
And
wait list.
that gives them standing for any mistakes that may occur down the road in the application process.
It does, Your Honor. Absent standing in this case to members of the wait list, the town would be free to make mistakes without the possibility of review in the administration of the wait list and the regulations.
Standing requires injury. What is your injury here?
The injury to High Maine is the diminution in value of its position on the wait list by virtue of an unqualified applicant being selected when it should not have.
But how does the wait list work? Once you're put on the wait list, are you put in order?
You are, Your Honor.
And where does your client stand in
I
that
don't
order?
think that's relevant, Your Honor.
Well, it's relevant if there's 18 other people ahead of you.
I disagree, Your Honor. The harm here to any member of the wait list, but in this case my client, is that it's forced to now wait behind an applicant that should not have been qualified, that should not have been approved.
But you didn't ever allege that you were qualified and you should have been approved if they get to you.
Well, again, I don't know that that's relevant. The code requires that a pre-applicant submit this application. It undergoes review by the town manager to determine completeness, and only if the application is complete and appropriate is it placed on the wait list. That is what happened here.
But is there an injury if you're the 100th company or applicant on that list versus being the first applicant on that list?
Absolutely. I don't think it matters whether you're the first runner-up or you're at the very bottom of the list. We don't deny standing to tort victims who've suffered $1 worth of personal injury damage. We don't deny standing to breach of contract plaintiffs.
The difference is that $1 worth of injury in a tort action is actual injury, and here what we're talking about is standing.
But it is, but the question before the court is, if I may narrow it down a little bit, is whether High Maine has suffered a particularized injury. And our contention is that it has, because it has invested time, energy, and money in submitting this pre-application, which requires a lengthy list
Well,
of
it's supposed to
conditions.
be direct and concrete injury, and if you're 259th on the list, is that a direct and concrete injury?
It certainly is, Your Honor. You are forced to wait that much longer behind.
But isn't there a point at which it's impossible, essentially? If you're 259th, you're just never going to get it.
I don't believe that's true. Even if there are diminishingly small chances that you'll ever be selected from the wait list, the point is that the pre-applicants in my client have expended time, energy, and money, submitted a pre-application, secured their position on the wait list. The harm here is the diminution in value and the degradation in the relative ranking on the wait list.
But what if, getting back to Justice Connor's question, what if there's a fatal flaw in the pre-application? There's something in there, you can fill in the blank, that makes it impossible. This organization will never get the license. Never
You're
gonna
within
happen.
200 feet of a school.
Well, I was going to circle around to that, but don't let me get ahead of myself. If there's a fatal flaw in an application, and you know this in the pre-application process, no chance of it having success, does that person have standing, even though, as Justice Connors was pointing out, the qualification is patently lacking? It's a little hypothetical, but...
They do have standing, Your Honor. I think your question, with all due respect, is that there's a little bit of misdirection in there. Because I think your question is premised on the idea that standing is dependent upon obtaining the final license. It is not. Our argument is that standing here is dependent upon the harm inflicted on High Maine by the town improperly approving someone higher up on the list when it shouldn't have. Had the
Yes,
town
this
not
is
done that,
sometimes known as the doctrine of equal footing, that you all have an equal opportunity and you're all measured by the same criteria. And that's why I was asking the question that if you don't meet the criteria, then how is it you can have standing under this theory that says your injury is that you're not being measured equally as others are?
Because again, standing is not dependent in this case upon obtaining the final license. It's dependent, standing arises from High Maine's property interest, pecuniary interest, in its position on the wait list, which it invested in, it secured, and has now been harmed because another applicant's been improperly elevated. Had that applicant not been elevated, High Maine would be that much higher on the wait list, that much closer to submitting a final application, being selected to submit a final application.
Can I just ask an extrajudicial question, which you don't have to answer if you don't want to? I'm just curious, are the facts still status quo today, the way they are as they're served up, or have something happened in the meantime that might have some effect on the ultimate decision we make here.
I'm not aware of that, but again, I think the question is before the court's very narrow. It's just the standing question, and if you find that High Maine has standing, I think the appropriate action is to remand for further proceedings before the Superior Court, in which case I think, Your Honor, your question would be answered at that stage in a proceeding on the merits.
Is there damage to its pecuniary interest just as a result of having a competitor get the license in this circumstance?
No, Your Honor. The damage, the High Maine's pecuniary interest in this case is its investment in its position on the wait list. Right? When you look at Appendix 4041 and the requirements in Code Section 5119C1A through D, those are fairly rigorous requirements for just an opportunity to secure.
Well, is that
position.
even before us if what we're on is a motion to dismiss a complaint for failure to allege?
It is, Your Honor, because in the complaint, paragraph 8, it alleges that High Maine submitted a pre-application and it is on the wait list, meaning it was
Well, I
approved.
understand that. But I mean, the terms of the ordinance, is that even before us?
Yes, Your Honor.
How?
That is the relevant ordinance before the court.
How is it before us on a motion to dismiss a complaint for failure to allege standing?
The qualifications as to the pre-application are incorporated in the code.
I understand. Is that part of the complaint?
It is, Your Honor. It incorporates by reference the code. It is fairly common practice for the record to include the relevant portions of the municipal ordinance under which
Not only is it common practice, it's generally required.
Yes, Your Honor.
But putting that, have we even gotten to the record yet, is my point.
Yes, Your Honor. You asked a question about the complaint, or the question was asked by Justice Connors about the complaint. The complaint includes an allegation, paragraph 8, that High Maine submitted a pre-application. The code simply details what the requirements were in that pre-application.
There are two aspects. You're challenging the site plan and you're challenging the license, correct?
Correct.
So the administrative record should include those portions of the ordinance relating to both, shouldn't they?
Well,
They
Your
do
Honor,
not.
Those issues are not before the court. Those are as to the merits.
So you can refer to the record when you want to, but we're not supposed to talk about whether it's complete or not.
I don't think I've forestalled the court from talking about whether the record is complete or not, Your Honor.
There don't appear to be additional questions.
Appreciate the court's time. I'll see you in a few minutes.
Counsel?
Good morning. May it please the court, again, I'm Cameron Ferrante for the appellee, Town of Kittery. So, as the court's heard, this matters about the waitlist process in the Town of Kittery that's used to issue marijuana licenses. That waitlist and being on that waitlist doesn't entitle you to being selected to apply for a license or to receive a license. All it is an administrative mechanism that's designed to avoid the chaos that comes with a first come, first serve process. Here, High Maine's essentially asking the court to infer standing based on alleged injuries to its prospective business interests and investment in the pre-application process. As the court has pointed out, there's nothing within the complaint actually establishing any of those harms. High Maine is essentially saying that merely because of its position on the wait list, it's entitled to have standing to bring this appeal. And I don't think that that's the case. First, any investment that High Maine has made in the pre-application process is effectively a sunk cost. That's something that High Maine would have had to do regardless of whether it's challenging the town's actions, merely to be placed on the waiting list. So the town's actions haven't affected its position on the waiting list, they haven't taken it off the waiting list, and they haven't affected any established pecuniary personal or property rights that would be necessary to establish standing to bring this appeal. Second, although the court hasn't quite discussed it yet, the alleged injuries to High Maine's prospective business activities, those are entirely hypothetical. High Maine's not an operating business right now. The town's actions haven't prohibited marijuana businesses in town or done anything else that's comparable to the existing case law surrounding sort of a generalized standing for extant businesses challenging town actions. So So based on just the impact of prospective business interests, I don't think High Maine has standing. The claims here really rest on three fundamental assumptions, and that's that High Maine will inevitably ascend to the top of this waiting list, which could include tens, hundreds of applicants, and that they'll actually be, receive that license once they're selected, and then that they'll, the town's actions have actually delayed that process from occurring. I don't think that any of those things are established in the record or are actually even knowable facts or assertable facts, simply because they're contingent on so many different things, such as the town's actual review of the pre-application and the subsequent application. There's no guarantee here that High Maine, were it to ascend, would actually ever receive a license or be eligible to receive a license. Additionally, although not quite discussed here, it's asserted in High Maine's briefing that if the court were to determine that it did not have standing here, that nobody listed on the wait list would have standing or be able to contest any of the town's actions, and that's simply untrue. Standing is unique to the appellant. Anyone on the wait list could come forward and establish, based on their own facts and their own complaint, that they've suffered a particularized injury and are therefore...
How? These other people who are on the waiting list?
So I don't believe that High Maine's entitled to any of the sort of context.
We're looking only at the allegations in the complaint.
We are looking only at the allegations in the complaint, so those individuals could come forward and establish that they have suffered a particularized injury by making the necessary assertions within their complaint.
What
and
necessary assertions?
Such as a reasonable expectation of obtaining a license or being selected from the wait list.
And how would they do that? What facts would they include in their complaint?
Well, I like to think of this case sort of in terms of the court's jurisprudence around abutters standing. So the court's held that, abutters have a minimal standing threshold because they're so closely proximate.
So you're saying essentially if they say that they're number 1 on the wait list, that might have standing. If you're number 10, maybe not so much?
I think that that's exactly right, Your Honor. I think that if they have the next person
in the Fitzgerald versus Baxter State Park case, we didn't look at how many other people used Baxter State Park. We didn't look at how often Fitzgerald went to Baxter State Park. Why does it matter how many other people are on the waiting list or what High Maine's position on the waiting list is if their ability to advance has been impaired?
So I think it matters because if you start extending the, in the context of like an abutter standing or something like that, if you start expanding the universe of potential appellants, what you're doing is really generalizing out and diluting the pool of interests that could be eligible, or the pool of appellants. What's wrong with that?
Yeah.
Well, as it becomes more attenuated, their interests become more like the interests of the general public, and then that removes them.
Well, what we look for in our prudential doctrine and standing is that there's somebody who has such a sufficient stake in the controversy that they're going to give us a serious argument as to what went wrong in procedural irregularities and why the person that was picked shouldn't have been picked because it's a violation of the code. Now, so far, they've been doing that, haven't they?
So I don't believe that they have so far done that because the only assertion within the complaint is that they're on the wait list. They haven't established that they've actually suffered any harm. Specifically, High Maine hasn't. I think the key isn't saying that there's a blanket determination.
They've alleged that you have picked somebody who is going to be within 1,000 feet of a school and who has violated your own rules. And nobody else has come out to say, look, town, you've got a store right in the proximity against state law near a school. Isn't that in the public interest?
I think it's in the public interest, but I don't think it's necessarily before the court at this point since it gets to the merits of the application.
If they have a sufficient stake because they're in the closed world of the waiting list, and if they've met the criteria, so they're not 1,000 feet of the school, then why wouldn't they be able to say, hey, this isn't fair? You pick somebody who's within 1,000 feet against the law, and we aren't. You should pick somebody who is legit.
Well, that relies on the assumption that they are legit and that their pre-application isn't similar.
Well, the allegation is not necessarily that you have to pick me next. It's that you should pick someone that is legit.
And I don't believe there's anything within the complaint that establishes that there is anybody who is legit.
So if we follow your reasoning, which is it's attenuated, number 1 on the waiting list has a strong standing argument, number 92 does not have a strong standing argument.
Well, number 92 could come forward and establish that they have standing by showing a particularized injury, by showing some type of economic harm, by showing some type of impact to either their existing business operation.
All they can possibly show, though, is that they've made the application and they qualify. That there's, under your analysis, they could never demonstrate standing on the 4 corners of the pre-application itself.
Well, that's because I don't believe that merely submitting a pre-application is sufficient to establish standing, because there's no lowered threshold here that's applicable to that
So
analysis.
no one on the pre-application list has standing?
No, that's not what I'm saying. I apologize if
Well,
there's
then
been
how
any
do you
confusion.
differentiate?
How do you differentiate? You differentiate based on the complaint and the allegations that are in it. and
What
whether those-
allegations?
Well, I can't hypothesize.
But that's what I'm not understanding, what allegations you think would be sufficient beyond, we are on the pre-application list, we submitted the forms, we qualified, and this dilutes our position. What other allegations are there that could be
Well, I think you need to
in this context?
Sorry, apologies for interrupting. I think you need to establish that you have a realistic possibility of obtaining the license, either by saying that you're X number on the waiting list and the people above you are unlikely or have dropped out or withdrawn and are no longer seeking a
So
license.
only number one?
So number one, I think, would be comparable to an abutter and would have a lower standing threshold. But I think as you get further down that list, you need to increase the burden
Well, do
on
we
that
change the
appellant.
standing threshold, or are we just saying that the injury is more attenuated? Are we changing the threshold?
I don't think you're changing the standing. Well, I think you're applying two standing thresholds, as the court does in the context of an abutter. You know, an abutter has a minimal threshold. All they have to do is make a reasonable assertion of a harm. Here, they're not, what would be considered an abutter. Really, they're just in the neighborhood, so they would have to come forward and demonstrate that High Maine has suffered some type of particularized injury to its personal property or
But in
pecuniary.
the land use cases, obviously the abutter gets a free ride, they're right contiguous to the property that's being addressed. Maybe a couple properties down might have standing because you could show the effect overlaps onto them. Are you making that direct analogy to the process here?
Yes, I think.
Well, it's not exactly a relevant analogy, because here, what the injury is they have competed. They say, if they put in the right allegations, we're following the rules, we follow the ordinance, these guys didn't, and we are not competing on an equal footing with those guys because the procedure was warped. And doesn't anybody who has been participating in that procedure, and that's not the whole world, it's not the public, it's everybody who's been in good faith proceeding to compete for that, don't they have standing?
I would think that they could establish standing, but I don't think that the complaint that's being presented here establishes that standing.
Okay, so are you saying the only provision that's missing here is a provision that says that they would have been qualified had they been chosen?
I think there needs to be something to that effect. I think the
So
complaint
if
right
that
now
were
is
the only thing that was missing, then everybody who fairly competed, who were qualified, has the ability to say, and those guys didn't meet the qualifications, and so they have standing to contest it?
I think, again, I'm not trying to say that nobody on the wait list has standing. I'm trying to say that being on the wait list gives you a reasonable basis for then coming forward and demonstrating that you have standing. You're in a universe of potential appellants, but you still have to establish that
But whether you're 259 or you're number 2, you still haven't been treated fairly if the person who does get picked didn't meet the qualifications, correct?
Yes, but I don't think that being the 15th
And
house,
isn't that enough, the not been treated fairly as a result?
I don't believe that it is, because there's nothing within the complaint to substantiate that. All they've said is that
Well,
they're
we're at
on
the
the waiting
pleading
list.
stage.
They've said
understand.
that these guys didn't meet it, and that means they've been treated unfairly, correct?
I don't think we can say that they've been treated unfairly, because we aren't at the merits phase yet. We aren't in the
Well, that's
We
the
aren't
point
in
of
a procedural
litigation.
posture.
That's the point of the litigation, isn't it? To the extent that they filed a complaint suggesting that the basis of their harm is that there's been an award to someone who hasn't followed the rules and in fact is being issued a permit that's illegal under the town's ordinances. Isn't that enough?
I don't think it is.
And they participated and objected both to the town council as well as the planning board, correct?
They did, but I think if the court were to say that anyone who's on the wait list has a blanket right of standing and can bring this type of appeal, then what they're doing, or what would happen, is you're inviting people who simply have dilatory motives or anti-competitive motives, could come in potentially after the town has issued a license, submit a pre-application, which, as the court recognizes, is essentially just a form with some supporting documents, be listed on the wait list, and then file a Rule 80B appeal.
So let me ask you a
that would have no
hypothetical
difference.
that isn't this case. With the waiting list, imagine there's a long waiting list to make it to the front, and you get far enough down the list that you can simply say, geez, number 72, it's just not going to happen for you because the line is so long, there's so many possibilities up here. Would that be sufficient just to knock them out, to say there's no realistic chance of you being considered?
I think they would need to demonstrate that they have a realistic chance of being considered. I don't think it's...
But if the opposite is true, no, it isn't your burden. I'm just saying hypothetically, if they're far down the list and everyone agrees and there's no way 72 is going to make it into the application process, are they dead in the water on standing-wise?
I think if they're able to come forward and demonstrate that they have suffered some harm, regardless of everybody else's opinion
So if
about
they're
the
like
realism of their
80th
application.
on the list, they'd have to prove that the 79 people ahead of them were not qualified?
They'd have to prove that the 79 people ahead of them were not qualified or that they otherwise have a realistic possibility of obtaining a license. So here I think it's important to distinguish between being affected by the town's actions and actually being harmed.
Well, we don't know how attenuated it is because it's not in the complaint, right? It doesn't say whether they're number 2 or they're 259. And you didn't wait until the administrative record had been filed. You decided to move for lack of standing at the motion to dismiss stage. So all we have is the allegations, and they could be number 2.
They could be number 2, but they have not alleged that within the complaint. And my understanding is that they're number 259th as the court is
Well, we're
represented.
obliged to review the allegations in the complaint in the light most favorable to High Maine.
You are, and I agree with that, but the allegations in the complaint, even in the light most favorable to High Maine, aren't sufficient to establish standing. They don't establish that they've suffered any harm to their property, pecuniary, or personal interests. And High Maine's not entitled to any reduced standing threshold here. They are, subject to the same threshold that anyone else has to meet in order to gain access to the courts. And their complaint, as it is written today, doesn't meet that threshold.
So how many of the businesses on the waiting list have standing in your view?
I would think the only one that would be entitled to a lowered threshold of standing
just
would be
one?
the first. I think anyone could establish standing, just as anyone who's opposing a gravel pit could establish standing, but it's up to them, and it's their obligation to come forward and demonstrate that they've been harmed by the town's actions. And here, High Maine hasn't done that.
But that would effectively go to Justice Connor's point. They would have to prove that every other person or every other entity ahead of them on the wait list was somehow not qualified.
I think that would be one way to do it.
There
So,
don't
with
seem
that-
to be additional questions. Thank you.
Thank you.
And Mr. Brandwein, you reserve 3 minutes.
I have not, Your Honors, but I would just like to address one point that the court and Mr. Ferrante discussed, which is abutter standing. The theory behind abutter standing is that the abutter's geographic proximity to the challenged land use activity, it means we understand that there is a greater potential impact on the abutter, and therefore the abutter has standing. That proximity principle, that's at issue here as well. The neighborhood of affected people to this challenged action is the wait list by virtue of the investment in the time and energy and money beyond the wait list. That same proximity principle should apply to this case. If you accept that a member of the wait list or an entity on the wait list has been harmed by virtue of an unqualified applicant's approval, then the only distinction between the harm suffered by the first runner-up and the person that's very last on the wait list is an issue of degree, not an issue of cognizable injury.
Even if, I'll ask you the same question, even if they're so far down the list that they never really had a chance of making it up to the front in any event?
You wouldn't be on the wait list, Your Honor, if you didn't have a chance, no matter how small that is. And again, the difference is a matter of degree, not a matter of the cognizability of the injury.
They're participating in a process, and if any one of them claims the process is defective, your argument is they should have standing.
Well, if there's a based on the complaint, a good faith allegation, sufficient pleadings to allege that the town did something improper, as I believe we've laid out in our complaint, then yes.
Do you agree that if you prevail in this case, in other words, if we agree that your client does have standing and you can prove that the license to GTF should not have been issued, do you agree the only relief you could obtain is to move one place up on the waiting list?
I do agree with that.
Okay?
And I think that is sufficient. That is a sufficient injury, being forced to wait behind an improperly approved applicant for who knows how long.
So if we accept your principle of law, anyone who, we'll say, bids on a government contract, despite the fact that they probably wouldn't have gotten it in the first place, any bidder can challenge the decision by the governmental entity that was not them.
Standing, as this court has noted, is very context specific, and I think what matters in this case, again, is the rigorous pre-application that had to be filed here, that High Maine did file to secure its position. That may not be the case in other instances where there is a wait list and parties secure their position on wait list through submission of some sort of pre-application. The circumstances of that may not be as rigorous, but where they are here, that rigorous, that creates a pecuniary and property interest in the position on the wait list that is harmed by the improper authorization of another applicant.
Perfect timing.
I appreciate the court's time this morning, excuse me.
Thank you. And we will, as is our usual practice, take this matter under advisement and issue a written decision in due course. It is also my understanding, Mr. Ferrante, that this is your first argument in front of this court. It is our tradition to invite counsel back to take the greetings of the court in the conference room. So happy to see you there.
All right.